A Zoom bomb. Ugh, just starting out with the word right away. I hope everybody is doing well, but what is in the poll question today? It is when somebody appears shockingly on the screen in a manner of undress or duress or distress or something like that. But it really is more than that. Generally, what happens is somebody has hacked. They say hacked, and this is what I want to talk about. I'm not starting with any Zoom bombs. I've seen multiples. They're really not that hard to do. I don't. mm, Now part of me is like, oh, do you even tell them? I will talk about it anyways. I want to.
All right. So I'm Commissioner Jill Carmy. Apologies for our belated start. We did on our 1 o'clock docket have a pretty egregious Zoom bomb. And so if that happens again, I'm kind of monitoring the waiting room a little more than normal. If I don't recognize the name, I'm not bringing them in. But if something does occur on this docket, please just log off immediately and I will restart the Zoom link. We also had some other dockets go a little bit long, so we are starting late. I'm just going to mute some folks whose cases are not on yet. First up,
Can you hear me now? I saw the audio going out for some reason. I don't know why, but hopefully you can hear me now. Um, so you can hear her talking about it, and Colin's exactly right. Hi, Chris. Colin's exactly right that it's not hacking at all because they literally publicly post their Zoom IDs, which it legitimately tells you in the Zoom instructions not to do. And I'm calling it right now, absolutely late, lackadaisical, let's call it, administration. If you wanted to be secure about that, you make everybody a new Zoom link or make it, you know what I mean? Like, there's so many ways to not make that happen. But like the fact that I can go and find oodles of people's Zoom links all over the place makes it a little bit disingenuous. Anyways, uh, I was making a bit of a joke here. I am wearing something, so don't you worry. But I thought it would be funny a little bit to pop up like that. Moonfox is here, Nancy's here, Chris Angleby's here, Christy Davidson's here, Cellulite Yoga Pants. Hello, hello, hello. Sashina, Jonathan. I hope that you guys are all doing well. Come say hello. Tell me what you have for dinner. If you didn't like what you have for dinner, tell me what you wish you had for dinner. Um, oh, on the link tree now. My Amazon is linked. Courtney's here. Yay. Steffi B is here. Yay. Um, we are, and I know Colin was here earlier. He's probably gone back to work. Miss Carrie, we are thinking of you. You let us know if you need anything, please. Um, well, you are in our thoughts. I can imagine no appetite. Uh, so we aren't gonna watch that civil docket. I was honestly on a bit of a little kick. Yeah, we're on day 2. We still can't find my medication, so I'm still not medicated. That's okay. I do have an energy drink, so that'll help. But So my brain is going a little all over the place, and I spent a lot of time getting a lot of different court stuff today. And so, and I was just listening to the first wee bit of it, and there it is. And that's what I heard from her. And it always bothers me when when courts fucking complain about being hacked, and there's no hacking involved whatsoever. But on the other hand, it should also be easy-ish to trace who did it based on the fact that they might just log in on their Zoom ID. Um, Pizza does sound really good all the time. I am gonna drink my energy drink. This is the only kind of energy drink that I drink, and I remember the first time I drank it, I was somewhat humble brag boasting to my girlfriend that I don't ever drink Red Bull. I've never drank Red Bull as I'm drinking this, and she's like, "That is Red Bull." And I was like, "What are you talking about? It's not Red Bull. Red Bull's on, it's blue." And then I looked at it closer and I was like, "Oh my God, it literally says Red Bull on it." And so now I've come to terms with the fact that I have indeed and do indeed drink Red Bull, I guess. This apricot version, apricot strawberry. So that's what I'm having thus far. And we are going to watch, here we go. Uh, some of Judge Hagen first, some new stuff that I'll probably make into a video later. Speaking of, the channel has 828 subscribers the last I checked, which is awesome and exciting. Obviously, some of that growth is to do with the, the videos, but some of it has to do with the live. So I just welcome everybody who might be new. If you watched an 8 to 10 minute video, this might not be your thing, watching lives, but that's okay. We do we watch the stuff live and then I make it down into videos. So, um let's watch a little bit of Hagen. These are new ones. I haven't watched them yet. And then we have a Kirkham video that I haven't watched yet. And oh, you can call me Kitchen. You can call me Paisley. You can call me almost anything you want, really. And then, uh, yeah, no, and I love lives too, Grammy. So I won't be stopping doing the lives, but I'm working on doing videos too. So these are friend of the court, show cause hearings, child support, les deux.
Okay, good morning. It's January 10th, 2024. This is date and time set for our front of the court show cause hearing with regard to child support. Ms. Conley, would you please state your name for the record?
Aaron Connolly.
Thank you. And Mr. Leonard.
John Leonard.
Thank you. And I do want to note, Mr. Leonard, you do have the right to an attorney. If you can't afford an attorney, the court will appoint one to represent you. Do you understand that, right?
Yeah, I do. Thank you.
Okay.
Aaron Connolly.
Okay, thank you. Ms. Mullen.
Tracy Mullen on behalf of friend of the court. This is the matter of Aaron Connolly versus John Leonard, docket number 2023-011-014 DM. This is the first show cause hearing for parties. They have a default judgment of divorce signed October 18th, 2023, which orders Mr. Leonard to contribute child support and medical support and child care for one child in the amount of $505 per month. The current balance on the account owed is $3,577, of which $3,416 is owed to Miss Connolly in child support and child care. There are fees and medical support to the state owed is currently $119. There have been no payments on the account since charges began in July of 2023.
Okay, Mr. Leonard, so what's been going on?
Well, what happened was 20 months ago, I overdosed and almost lost my life. My leg was very nearly amputated. They had to take out a lot of muscle. And so I had to heal. And then I didn't get along with my dad, so he threw me out. And I met some guy at a bus stop who's disabled. And what happens is I tried to go back to work twice. And when I go back, what happens is I'm down for like a week. I can't do it, and I can't even concentrate, and my mental state was out of control for a long time. I wasn't sleeping. The medicine wasn't putting me out. I just now actually been able to sleep properly, and I've been sleeping quite a lot. And this is, I didn't think this was going to be this long of a process, Your Honor. It's been really crucial, and I wish there was more I could do right now, but I have to respect my body. I'm still healing, and this is just what's going on. I have a lawyer for disability that I've been waiting on for quite some time now, and he says he thinks I should get it. That's why he took my.
Courtney, that's exactly what I'm wondering too. Where does Bus Stop Guy come into this story? Why was he brought into it? I'm not trying to be mean at all. We are going to have to just go back and listen to that again because what? Hi, Walter. I have so many questions. Also, yeah, I'll be making this into video. I think I'll probably put the excuse counter up. Yeah.
At a bus stop who's disabled, and
$18. There have been no payments on the account since charges began in July of 2023.
Okay, Mr. Leonard, so what's been going on?
what happened was 20 months ago, I overdosed and almost.
First problem, 2023 of July, he made a payment. But 20 months ago, he got this problem started. So I'm already sensing a discrepancy in our timeline. Right?
Almost lost my life. My leg was very nearly amputated. They had to take out a lot of muscle, and so I had to heal. And then I didn't get along with my dad, so he threw me out. And I met some guy at a bus stop who's disabled. And what happens is I tried to go back to work twice, and when I go back, what happens is I'm down for like a week. I can't do it, and I can't even concentrate. And my mental state was out of control for a long time. I wasn't sleeping. The medicine wasn't putting me out. I just now actually been able to sleep properly, and I've been sleeping quite a lot. And this is, I didn't think this was going to be this long of a process, Your Honor. It's been really crucial, and I wish there was more I could do right now, but I have to respect my body. I'm still healing, and this is just what's going on. I have a lawyer for disability that I've been waiting on for quite some time now, and he says he thinks I should get it. That's why he took my case. And so I wasn't even supposed to work, but I still tried anyways, but it's not going to happen. My body won't allow it.
Okay, do you have any paperwork that you could provide to your caseworker that would show what's going on with your medical and what's going on with the disability case?
I talked to my lawyer. He said that he could fax all this stuff. I could just, but I mean, yeah, I could get the paperwork for everything and do it.
Yeah, well, we need to see that on our end to see what's going on to make sure that whether you have the ability to work. Can you get that to us in the next 14 days?
Yeah, exactly. What is it again? Everything?
Well, anything that can corroborate what you're telling me. So if we have
Yeah.
paperwork that says that you can't work, or paperwork that says that you're in the middle of a disability claim or whatever's going on, we need to see that information.
Yeah, I can do this.
Okay. Ms. Conley, anything you'd like to say?
In the time that I've known John, and recently since his medical issues, I agree. I don't know that he can work or hold a job. So that's.
Okay, so we'll do this to then I want that information, Mr. Leonard, as soon as you can. So in the next 14 days, try to get that information to your caseworker. I will make a finding today, though, that you don't have the ability to pay, and we're going to dismiss the contempt. But we need to see that paperwork, because and keep us updated, sir, because after a certain point, we may have to go back on this enforcement process. But if you keep us updated, then we'll know what's going on with you. Okay?
Yeah, for sure I will. I mean, honestly, I just now been able to think straight and keep a lid on it, and everybody on my down here on my dad's side are all unstable. They get high and drunk, and so this guy I'm living with is disabled, and meanwhile I'm just trying to keep a lid on it, and now I'm just starting to figure out, you know, I can do this and that myself, you know, and it was so bad for a while.
Okay. We'll just make sure you stay sober and get us that paperwork. Okay?
Yeah, I will do that, Your Honor. Thank you.
All right. Thank you all.
Thank you.
Thanks.
Next, I'll bring in Mr. Showman.
Thank you. All right, it's January 10th, 2024. This is a date and time set for front of the court show cause hearing with regard to child support. Mr. Showman, if you'd state your name for the record, please.
KCC Showman.
Thank you. And sir, I want to advise you that you do have the right to an attorney. If you can't afford an attorney, the court will appoint one to represent you. Do you understand that, right?
Yes, I do.
Thank you, Ms. Mullen.
Thank you. This is the matter of Ashley Garber versus Kitchi Showman, docket number 2016-009844-DP. Parties in this case have a first order modifying order for custody, support, and parenting time, signed March 27th, 2020, which orders Mr. Showman to contribute child support and medical support for one child in the amount of $253 per month. There's been prior enforcement on the case. Payments made currently have been we received May 2023 per cap in the amount of $607.05. September received a $200 reduced bond payment. And then in November, per cap posted again, this case received $1,174.38. The current balance owed is $3,636.47, of which $2,644.28 is owed to Ms. Garber in child support. The state is owed $382.19, and then there are fees and costs.
Okay, Mr. Showman, so what's been going on?
I have one quick question about the payments real quick. There was a survey thing that I filled out for the tribe, and that was for a stimulus check for $1,100. And they stated that if we completed that survey that we would get it for emergency stuff like utility bills and food and whatever else we needed help for in the house. And I don't recall when that was, but I do know it was between now and May. You guys didn't, and I got a check stub saying that it was taken for child support. You guys didn't receive that? Well, I mean, I hear that you guys said you guys got May's, and then you got the reduced bond for 200, and then again from per cap, and for November or whatever. Was that November per cap, or was that?
It appears to be, Mr. Showman, it was a total amount of $2,216.12, but it was split between your cases.
Okay, so you guys never received that. Yeah, that's crazy, because they did this to me on two other of these stimulus checks, and they were saying that the check stub shows that it went straight to child support, and I'm not hearing any of them in the whole junction of the payments. So I guess I'm gonna pick that.
The whole junction of the payments. What is he talking about? What is going on? Did he legit? I thought she just said they got the payments.
I'm gonna pick that up and see where that's going with that. But that's just a whole different thing. But I just want to touch base with you guys I've been dealing with a physical thing inside of my body, and
Oh, what is going on? What is going on? Oh, that's good, Lisa. Yeah, I was gonna say I'll look into that later. I haven't seen it yet, but wow.
had just there was a couple times before in the past year that I don't that it came about, and it was just it came and left, and it was like here for like 2 days, 2 or 3 days, and my whole body like seized up, and just it was like in a one big cramp, and it went away, and I didn't do nothing about it, and then it happened again a couple months later, and then it went away, and I didn't know what it was from, and then it just started happening again within the last couple months, and I had went and got some blood work done, and I was trying to talk to somebody on the phone about this, and I don't know if they was just assuming that I was trying to file for Social Security and trying to get out of paying my child support. But I do know that that I have my little ones here with me, that I'm helping my girlfriend, the mother of them. I'm here helping them, taking care of them, and I've been wanting to get into work and get these payments start taking care of my payments with the child support. But I'm dealing with this current medical situation that I have. I was trying to explain them that I spoke with somebody on the front of the court on the phone, and I was trying to explain to her what was going on, and I was just letting her know that I had court, and I don't know if she just assumed that I just was going to go through all that. I didn't even know that was an option. I do know that my one of my uncles receives Social Security, and he only gets like $900 a month. And I understand, like, if I'm able to find a good job, I can make that in 1 week. If not, I mean, given the work history and the criminal history that I have, I don't expect to get a job like that. But that's not something I'm looking forward to. And I spoke with my doctor yesterday. She has no problem writing up anything, but I'm not trying to have the courts excuse me from all of my future payments. I just need to have time to get this established and get this taken care of, because it is an issue, and I can't really do nothing. I went to go do some paperwork, and I
Sir, just
couldn't even
one second, okay? Let's cover a couple things here. You said you spoke with your doctor yesterday. Can you get that paperwork to your caseworker, please, so we can verify some of your claims?
Yeah.
Can you do that within the next 14 days?
I can get it done in the next couple days. I'm just at the step where I just had got blood work done in the last 2 weeks, and it came back positive for the highest level of rheumatoid arthritis.
Okay, so if you can get us any paperwork from your doctor or whoever's treating you about whether you have the ability to work currently, that would be great, okay?
Yeah. And
then the other issue, if you could speak with the tribe about the stimulus checks, that would be great too. Because what I'm going to do is adjourn this out 60 days, and we'll check back with you in 60 days and make sure that you've got this information for us. Okay.
Okay.
Okay. Thank you very much, sir.
All right. Hey, excuse me. Hold on. You said I get this back to the caseworker?
Yes. Yep.
Okay. Or am I able just to drop it off at the child support office?
Yeah.
Or just the caseworker?
Any of our offices in the 13th Circuit will be able to process your paperwork. So yeah, you don't have to get it to your caseworker specifically, but it sounds like you've already been in touch with her.
Yeah. All right. So just one more thing before I go. is this am I able to put this? Is this gonna go in the record for Priscilla McFall too? Because I have a case in Grand Traverse County, and I know that when I try to get a hold of one of you guys, either Leland or Grand Traverse, that this covers the phone number covers all of them. So I just want to know if this is going to be able to go over in the notes with the Traverse City case.
Yes, Mr. Showman. Best case scenario, just put both of your dockets on there, so a copy will go to each file.
Okay.
And I'll update Mr.
All right,
Salami
thank you.
as well. Thank you.
Okay.
Wow. What a freaking. He talked that entire time. I wonder what will happen next time. Let's watch our next friend of the court show cause. There's a bunch of small hearings today, basically, that we're watching.
John, we'll get started here.
Also, watching full.
Okay, this is case number 139049 Two Crow versus John. Today's date is January 10th, 2024. This is a date and time set for a proposed license suspension hearing. Mr. John, if you'd state your name for the record, please.
Thomas Harold John Jr.
Thank you, Ms. Mullen.
Tracy Mullen on behalf of friend of the court. A notice of proposed license suspension and request for hearing was sent to parties on October 27th, 2023. There was no response from Mr. John or request for hearing, but we did proceed with a motion to suspend license and notice of hearing, which was served November 21st, 2023 for today's date and time. We haven't had success in an income withholding or regular payments being made on the account. The case is now arrears only. There was one child between the parties. The last charge on the account was $463.94 per month based on a Wisconsin order that we are registered to enforce. His current balance, because the arrears only began in May of this year, I'm sorry, in June of this year, his balance is now $10,100.90. At the time the motion was filed, it was $11,698.54. As far as payments on the account in the past year, in April of 2023, this case received $69.88. In May, it received profit sharing income, $815.24. And in November of 2023, $1,618.64 was applied as a profit sharing. Mr. John was found in contempt back in March of 2022, and at that time he was placed on a payment plan, to which he does have an active warrant, which was issued in February of 2023 for non-payment.
Is that warrant that when you say it's active, that means it's still out there?
Yes, Your Honor.
Okay, so Mr. John, what's been going on?
Well, I didn't realize there was a warrant. Well, honestly, it's been a hard 10 years. My brother just lost his battle with cancer just this past June or July, and we've been having a hard time with this whole thing, just dealing with it. We found out, like 10 years ago. And it's been real tough on us. That's my youngest brother. And 3 weeks after that, my oldest sister lost her youngest daughter to cancer. So I kind of did what my dad did. He just, opens letters and doesn't really read. He just kind of goes through the motions. But I didn't know there was a warrant. I've been trying to get back into the casino, and I have to talk to the manager to get a I don't remember what they called it, but I got to talk to the manager to get back in there. And
the manager of what?
The casino. Sorry, the Leela Sands out here.
Okay, well, today we're trying to figure out whether we should suspend your driver's license. Do you understand that?
Okay, I'm trying to explain that to you. So anyways, yeah, my dad didn't realize that his license had gotten suspended, and he's got to wait another 4 months. So I have to chauffeur my parents around. My dad's 80. He's got early dementia, and I don't think he should be out driving around by himself, for one.
Okay,
Two,
so
I would also,
when are we going to
Huh?
start seeing steady payments? I mean, this is arrears only. What can you pay a month so we can just get this thing settled?
I'm sure I can come up with at least 100. I mean, once I get it in the casino, it'll be automatically taken out of the paychecks because they already have a what you call it filed. When is income withholding?
Right, but if you're not working, it doesn't matter.
Well, I would need the license to get to work also.
I understand,
well.
but you haven't been doing that. You haven't been doing that, so how can I make sure that you'll use your license to head to work?
I don't know how to answer that. That was kind of a open-ended question. Well, I had planned on going down to the casino and go see the manager today. It's pretty much just being held up paperwork-wise. Trying to get back into dealing cards at the casino.
Okay, here's what I'll do. I want to see 100. I'll adjourn this out 30 days. I want to see $100 in that time, and then as long as you go to the casino and ask them, if you can get a job, that's all I'm worried about, sir. I just don't know that
Yeah.
you're going to do that, and I need you to help me understand what your plan is. Okay, so because with arrears only, I can set the amount at what's reasonable. I'm not going to do that just yet because if we come back in 30 days and you still haven't gone to the casino and you're still not looking for work, it doesn't make any difference to me if you have your license or not, because if you're not planning on work, then I don't know what you need your license for anyway. Okay. I know you said you're taking your parents around, but it sounds to me like you're able to work and we're just not seeing any money come in at all.
Yeah.
$10,000
A
is
lot of
quite a
it.
bit. So I have to figure there's nothing I can do about the arrears. That's up to
Okay.
you. Okay.
Okay.
So what I'm trying to do is give you a chance to show me that you're planning on doing what you say. And if you've got the casino job moving forward, we're going to be good. I don't want to take your license away. That's the last resort, but I'm not recalling. I guess we can recall the warrant, but if you fail to appear in 30 days, we'll just send another warrant out. Okay.
Okay. I see.
So I'll recall the warrant for today.
Thank
But
you.
I want to see that $100 paid by next hearing in 30 days. And then I need to see that you've not just talked to somebody at the casino. I need you to either have that job or have a different job.
Okay.
So I'm just basically adjourning the decision on whether to suspend your license at this time because we got to figure something out.
Okay.
Okay.
Yeah.
Good luck. Thank you.
Judge Zach Morris. I like that, Colin. He is Judge Surfer Dude, however. You should know that. Next. Oh, next we have a 3-minute clip that I just had to put in because of you'll see why. You'll see why.
And Serena O'Dowd Jackson. They are 16.
Are you currently pregnant?
No.
Do you recall signing complaint for divorce on February 14th of 2023?
Yes.
At the time that you signed that complaint for divorce, were all the allegations in that complaint accurate?
Yes.
At the time that you signed that complaint for divorce, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Calhoun County for at least 10 days?
Yes.
The complaint states that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved. Was that true the day you signed the complaint?
Yes.
Is it true today?
Yes.
If the court, for whatever reason, were to refuse to grant you a divorce, would you go back and live with Mr. O'Dow Jackson as husband and wife?
No.
Um, we earlier reached a settlement at mediation as it relates to the issues of custody and parenting time. Is that correct?
Yes.
And did anyone threaten or coerce you to get you to agree to that?
No.
Okay. We've also reached a settlement as it relates to the economic issues, and you signed a judgment of divorce yesterday and then a corrected one this morning. Is that correct?
Yes.
And again, did anyone threaten you or coerce you into agreeing to that?
No.
After a conversation with His Honor this morning, after I had a conversation with His Honor this morning and then a conversation with you, is it true that you agreed to drop the issue of dividing up your student loans?
Yes.
Okay. Are you seeking spousal support?
No.
Okay. Do you understand that by not seeking spousal support today, that you are not seeking and you're giving up your right to ever come back and ask for it in the future?
Yes.
Okay. I have nothing further. Thank you.
Court is satisfied that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs at this time.
Is this a lie detector test? Yes. Will you pass it? No. Hi, Mikey. I hope you're doing well. I had to play this one because of Abe Lincoln. That lives in that spot. Like, I just would love to know what day that happened. It was years ago because I've seen it years ago, like in this lawyer's office. So I just, first of all, I guess I wonder, was it written off as a business expense, like a Zoom background? That's basically what we've got here. Um, but yeah, I love it. Anyways, also, she does sound very robotic, like she's on a lie detector test. Also, Colin, you applied for a job? Good job. Fingers crossed. Aren't you doing remonetization soon? Isn't that the plan? The plan diddly plan?
Pending, again, receipt of the judgment, UCSO, and the approval of the front of the court. Ma'am, that may take yet a couple of weeks. So just be aware that you won't be divorced until I actually sign those documents. And all I can say is good luck to you. I hope everything works out for you. And you're free to go. Have a wonderful day.
Thank you.
Something that we thought, and now we'll do. I told you, it was a bunch of small clips today. Are we here about Paul's hair? About the crime that was committed against him? Why is his hair cut like that? Who did that to him? Who did that to you? Your sad little eyes, Paul. What happened? Where did you go? Did you tilt the bowl when you were getting your hair cut? I mean, this is a serious crime. His hair! Right? That can't be a cut done by a hairdresser, can it? Could it? Would it?
Hello?
Hello, we're getting ready to go on the record.
Okay.
The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2011-51 DM, Lisa Spatari versus Douglas Giro. Today is Monday, January 8th, 2024 at 10:31 a.m.
Court will note the appearance of Mr. Umlauf on behalf of the defendant in this matter. This matter is before the court on the plaintiff's motion to show cause. Ms. Garreau, I have read your pleadings as well as Mr. Umlauf's response. Is there anything else you'd like to add?
Yes, Your Honor, there is. In regards to under his motion and affidavit, number 2, he denies as untrue. I deny that. I was awarded 50% half. And under number 3, I deny that. It was abuse in plain sight. And under number 4, I deny that. It is not true. He received a letter from me in March and never responded. And Mr. Umlauf could have asked the court for more time.
Okay.
And then,
ma'am, let's get to the meat of the issue. And it sounds like, you know, that based upon Mr. Umlauf's response, and I think you had repeatedly stated that the Newell Brands had in fact honored the request for the pension, that you received those funds. Is that correct?
that is correct, Your Honor, but that does not make me whole. I was whole when I left the marriage and was awarded 50%. And then having to go through all of this court battle with the court system, Newell Rubbermaid, all my costs involved.
Okay,
The fact that I was
let me ask you this, ma'am, and unfortunately, I'll tell you, because you represented yourself, that is in fact an issue, and a lot of what you went through is stuff that attorneys would be doing if they had represented you. In these matters, it's not unusual that companies will change, they'll merge, they'll be bought up, etc. And oftentimes the attorneys have many issues to attempt to locate and get the correct entity that it now handles and carries the insurance, or not insurance, I'm sorry, the retirement or pension, etc. So it's not unusual what you went through to collect that when you're dealing with those particular entities, as opposed to what you do dealing with the defendant. So the court is more concerned about what the involvement or what your relationship was and what happened with the defendant, as opposed to a third party that he has no control over. So what was there that you claim that he didn't do that he should have done, as opposed to a third party?
He should have not withdrawn and depleted the account. I was awarded that amount.
Okay, you received that amount though, ma'am.
Yes, I know, but after much, okay, you're saying that if I would have hired a lawyer, which I had to help myself because I cannot afford a lawyer. I have not been able to work. I'm living off of my savings.
Okay, ma'am, this is all extraneous. I just need to know what it relates to your particular motion.
What it relates to is I was whole when I divorced.
But you have not, but ma'am, you've now since, ma'am, you've since received all the money you were supposed to receive pursuant to the terms of the judgment of divorce. Isn't that correct?
Your Honor, I have received my funds, yes, but I have
Okay.
not been made whole. I want to be made whole.
Okay.
I
What does that even mean? I'm sorry. Like, what does that even mean? As in, you want his dick back inside of you? Sorry, that was inappropriate. But seriously, what would that mean? I'm not like I'm just thinking like filled? Fulfilled. I mean, I meant to say fulfilled.
had to go through, whether I hired a lawyer or not. This is about gender discrimination. Okay. This happened to me because of gender discrimination. And I had a lot of suffering. I had to help myself. And now I'm being told because I helped myself that, and I've been paid funds, that all that my ex was allowed to do to me, that was okay. Well, that was not. Now I need to be made whole again. I had to, whether I've hired a lawyer or whether I did it myself, I had to go through so much more to get the 50% that was awarded me. And that's not right. You can't just destroy somebody's life and then go, ha, 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 and commit a crime and say, now you pay for it. It doesn't work that way, Your Honor.
Okay. Ma'am, what I was trying to highlight to you before when I started is that that happens in a lot of cases. It's not just your case, that oftentimes when you're dealing with companies with pensions and retirement programs, that it's not unusual. Some of the things
It's not unusual to be loved. I can't not hear it every time. What is she talking about? This will be a video too. My God. Seriously, what is she talking about?
you experience, that you would experience those. And that's the only reason I brought that up. So you would know that it wasn't anything unique or simply pertained to your case. So with that.
Your Honor, I understand that.
Okay.
And this problem is bigger than me. Okay? But
Okay.
I'm focusing on just my case.
Okay, thank you. I'm gonna let Mr. Umloff speak. Mr. Umloff, I have received your response.
And also your complaint about your hair, which doesn't seem so big now with the big global problem of gender discrimination within the justice system. I guess that's what she's arguing, but she hasn't even made a motion. What does she want to be made whole again? This is confusing. Diamond painting. Dana, I'm doing diamond painting too. It's very fun. You can come diamond paint with us. It's hard to be in the chat and diamond paint, so I get it. But if you do it live with me.
Anything else?
I would note that the allegations that criminal activity took place are simply false. The August 16th letter shows that she was indeed made whole. What happened here is my client believed that everything was in order and that the account had already been divided up when he took his lump sum payment, and I believe it was 2015. It's unfortunate that that happened, but again, she has been made whole. And so for that reason, and Your Honor certainly knows it's not unusual that even attorneys sometimes have trouble getting QDROs prepared and getting them to conform with the specifications of each individual company and pension carrier. That can happen. But ultimately, my client did not do anything wrong. He did not do anything to harm her. He did not impede the process. It was the defendant's responsibility to prepare these QDROs and get that money. It took her much longer than ideal to do that, but it was not his responsibility to prepare them.
Okay.
Thank you.
Thank you.
Chris, yes, the one linked in my link tree should be updated. Should be called KCCs. And I think it should be updated. I put a bunch of notebooks on there. Again, that's also a place where I put things that I just like remember that I want. Um, but yeah, it should be updated. I think there's a Linktree link in here. Yeah. Look at all you guys are so good at that. So, I love it. This lady is fucking Karen. This is a Karen lady if I ever heard before. She is complaining even though she got all her money. Lady, how often do we hear people complain when they have all their money? That's pretty rare. Usually they start complaining when they don't have their money, but when they do, that's weird.
Anything else, Ms. Guerrero?
Yes, I deny that. It was a court order that needed to be followed by law, and he knew what he was doing when he withdrew all of the amount, and I did do nothing wrong. I turned in my quadro. It is a court order that needs to be followed by the law. And for him to be able to reach out after the divorce to cause me harm does constitute a crime. A crime under Michigan law states that crimes caused by some type of action that can cause extreme harm psychologically are classified as a felony. This defendant's statement by the attorneys and are unfounded claims under Michigan law is gender discrimination, as these types of cases are typically women's issues that are not covered for what they truly are, evil crimes.
Okay.
Although I have lumped
Well, ma'am, just to clarify, I will tell you that in these, over the years, I've seen these instances. And again, they're not unique to the female gender, that in fact, when men have had received a QDRO or something, they've been in my court time trying to get enforcement of that, or have had difficulties with the companies, just as you experienced. So I'm not minimizing the fact that it may occur more with women, but we've had enough occasions where it's occurred as it relates to men getting QDROs entered and getting them paid, et cetera. So,
Your Honor, I'm not saying that you are. I'm saying it is discrimination.
okay.
And I'm saying that there is a court order, and a court order must be followed by law. And no one, not Newell or Douglas Giroux, have a right to not follow that court order.
Okay.
And that court order was not followed in plain sight by Mr. Giroux when he took out that money. And he knew that. He was aware of his balances. He didn't need the money. Why would he have done something like that? Why would he have reached out after the divorce to cause me harm? You know, I left him to get out of that divorce.
Okay. Ma'am, again, you're going into extraneous things that don't apply to this particular motion. So I just want you to confine
well, I'm
yourself to the
asking
motion.
why. The burden of proof is on him.
Okay.
What happened to the other half of the money? The pension laws are you have to be 55 and older before eligible. He withdrew money at 52, and that was half. What happened to the other half before that?
Okay.
And how was, those are the issues, Your Honor.
Okay.
They're in plain sight.
Okay. Well, in this particular matter, the court will make the following finding: that in this case, the plaintiff does acknowledge that she has, and she acknowledged that in her pleadings as well as in court today, that again, there were some issues on the collection of her portion of the pension pursuant to the QDRO, that the QDRO was delayed substantially for a period of time as she was preparing those particular pleadings, that again, the company, Newell Brands, subsequently did.
Guys, earlier I was talking about my favorite mug, and I can't use my favorite mug on camera because, well, there's multiple reasons. Let's just say the imagery is too personal to share. However, what I want to say is, Bubba, Bubba, this is not my favorite mug yet, but it could be, just like your hashtag not a sponsor yet. But believe me, this could be my favorite mug. We'll see.
Honor her request that she received all of the monies that she was supposed to receive in this particular matter, although they were again delayed. But again, the court doesn't find that as being unreasonable. It's unfortunate, but it's not unreasonable that it does happen. As a result, the court doesn't any willful, intentional conduct on the part of the defendant in this particular matter. Maybe he withdrew that, maybe it was an error, but it was subsequently remedied in this particular matter, and she was paid the full amount that she was entitled to receive under the terms of the judgment of divorce. The court does not find a basis for the show cause. The court will deny the petition in this matter. Mr. Umhoff, I'll ask that you would prepare an order denying the motion and concluding this matter. So thank you both. You're excused. Have a good day.
Thank you, Your Honor.
Thank you, Your Honor.
In the waiting room, I do not have Cheyenne Nelson present. Calling case 2023-15-003, Junior Cheyenne Nelson. Today is Monday, January 8th, 2024 at 10:44 a.m.
Court will note that this matter is before the court on the plaintiff's motion for entry of default order, custody, parenting time, and support. The court will note it is scheduled for 10:30. It is now 10:44 a.m. The defendant has not appeared. As a result, the court will enter the order that you've submitted in this matter. Is there anything else, Mr. Prude?
No.
Okay, thank you. We'll get that entered. You'll be able to acquire copies of that from the clerk's office if you desire.
His last name is Prude. Okay. High Shadow Night Wolf Hector Cam Clips. Credence and Mikey, I already said hi. MB, I don't know if I said hi and thank you, but hi and thank you. Christy Davidson's here. Guys, make sure to hit the like button. We are doing a smorgasbord, a mishmash, buffet of court, if you will. And I'm drinking it out of my second favorite mug. I'm drinking this coffee out of my second favorite mug. Yeah, we've gotten the big D a couple times tonight. It wouldn't be prudent to call him that, Hector Cam Clip says. Oh, fuck. Hilarious. We'll do another hearing of this and we'll see what happens. Originally I had one. Let me see if I can find it.
Copies, okay?
Yes, sir.
Okay.
What? I do have a question. What happens next after this?
Well, I can't tell you. It depends on what's going to happen in your case, if anything. The court's going to enter the order, you'll have the order, and then matter will just proceed from there. I can't tell you what's going to happen because I don't know.
Okay.
Okay?
Yep.
Hi, Heather. It's not that one. Is it that one? Is it that one? Is it that one? Think it might be this one. Oh, it'll be the first one that I fucking downloaded. Yes. Hi again, Chris Engelby. Glad you're still here. Feeling okay. I gotta go to 5 minutes into this video.
said in the
Is now in session with the Honorable Brian Gickerkin presiding. It is Wednesday, January 10th, 2024 at 8:36 a.m.
Good morning, Mr. Chapman.
Good morning, Your Honor.
You can go ahead when you're ready.
Thank you. Before the court is Miranda Kelly of case 074109DZ. Miss Kelly is
Zed. We all know the correct terminology is Zed because I'm Canadian and that's the way it is. Also, if you're just getting here, make sure you like the video. We might be at 829 subscribers. Rounding up towards 850, 900,000. I'm so excited.
here today after failing to appear before referee Cruteau on April 4th, 2019. Bond is currently set at $500. This is the 10th bench warrant. She reports no employment. Last payment made on this account was in April of 2022. Front of the court recommends that a reasonable bond
830 subscribers. I'm so fucking excited. You need interpret from Canadian to American. What did I say, Zed? And look at all the followers or the people that I've left to go unsubscribe, but that's okay. Apparently, here's a more Canadian word than a boot. Pasta. Would you guys like some pasta? Apparently, that is not how Americans say it. But if you would ask me what that thing is that we buy at the store that we sell with or we serve with sauce, I would say pasta. Oh, yeah, absolutely pasta. Jim Huntsman. Oh my God. A bagel? I would say bagel. Taco. I'm having tacos for dinner, but I would rather have pasta. And at the worst, I'll have a bagel. That's how I would say all of those things. But do not ever serve me pasta on a bagel. What's the other one? Can't remember. Oh, with tacos. Schedule. But did you see how I originally went schedule? Schedule. But pasta, bagel. I'm gonna go pick up bagels from the bagel factory while I pick up my pasta. What? Does that sound weird? The bagel factory is just down the way from the pasta factory. Now listen, nobody here wraps their pasta in aluminum, but I have seen people wrap bagel sandwiches in aluminum foil. Here we would never say aluminum foil very often. You'd say tin foil, even though it's not tin, but we would say tin foil. Thank you so much. Pasta money. Aluminum. I would say aluminum. Like there's aluminum siding on the house. Aluminum. And I would also say saran wrap. My default term for what I guess cling film or plastic wrap, I would say saran wrap. But pasta, apparently, I recently was watching a YouTube short and the whole like joke was about the pronunciation of pasta. And I didn't get the joke at all. I didn't find anything weird about it. It was just absolutely the same. And then I would, yeah, just the same. Anyways, to say soda or pop, I say pop. Like I'm picking up pop at the store. Could you get me a pop? Now, lucky for me, I can say that's not how you spell toque, Moonfox, but that's cute. It's Toque, and it's correct to say toque, not beanie. I know, and I got called parsley a lot, Victor. But I drink Coke, so I would order Coke, but back in the apparently down in the South, you could order Coke and they'll be like, "What kind?" And then you're like me, I would be like Coke, but somebody else would be like Sprite, and that wouldn't be weird. Colonel. I would say Colonel, Jonathan. Dawn, Orlando Chiquita gifting memberships too. Lieutenant. Aren't those right? I didn't think there was any other way to pronounce those. Oh, lieutenant, you mean? When they would call them lieutenant? Uh, see, again, I have a weird British slang terms because I was born in Scotland and my family's from Scotland, but not like high-end British. We're talking Glaswegian slang. So we wouldn't be talking about lieutenants or lieutenants. Fucking redcoats. No, just joking. Color, of course, and I spell them the right way with the U's. Arse, I can say that.
And be set in this matter and it be scheduled for hearing on January 17th, 2024 at 8:00 a.m. before this court.
Ms. Kelly, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on January 17, 2024, at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, ma'am?
Not at $500, sir.
Okay. Well, the court notes that you have had.
The court notes that you do not have a Canadian RCMP wear redcoats. That's true, Doggy Deb. I'm really fucking on different tangents here, but Moonfox, I'm glad you're learning. I'm learning too. Here's the thing. I've grown up. You have to remember my brain's a little different than everybody else's. Well, everybody's is different than everybody else's, but mine again is I have aphantasia, so I don't have any visual imagery. But I've read a lot in my life. I read books because there's no pictures in my mind. I can devour books very quickly, but words mean things to me. So I remember how to spell and I remember words in a different way. Like Wednesday. When I say Wednesday, I say it like that. But when I want to spell it, I go Wednesday to remember how to spell it. And not that I don't know how to spell Wednesday, like I do, but I don't know, my brain's just fucked up a little bit. I'm only learning this now. I really didn't know that everyone had pictures in their brains and I was a little bit I'm a little bit fucking pissed about that. I'll say that. I watched Fantasia once too at Disneyland. Actually, I think I've seen it a couple times. Also, you guys, I may have found some VHS tapes of me as a child, but I need to find a VHS player. Should I add that to my Amazon list? Do they have those? I need a VHS to play these VHS of me in Florida when I was like 5 years old. Because I want to watch them again. I think that'd be fun. My brain is it's called aphantasia, if that's what you're asking, Chris. Also, I have ADHD, pretty severe, and I'm unmedicated today, pretty severe. And get them at antique stores. Oh, go to an antique store to get a VHS or a VCR. VCR, that's what it is. Have a Best Buy? I think we have a Best Buy. Colin, thanks for being here. Appreciate you. Add it to Amazon. VHS with USB. Ooh. Yeah. Fucking rights. Okay. I have to do that pretty quick here, though. I'm going to do it on my phone because I'll tell you why. No, I'm not going to tell you why. Let's just say I'm appropriating the VHS tapes.
Previously, it had 10 bench warrants, so it looks like this is a course of action of simply not showing up for hearings. What I'm going to do, the court does believe it's appropriate. I'm going to leave the bond currently in place at $500. If you're able to post that, you'd be able to be released. Do you have any questions?
So I just sit here until the 17th?
Yes, you will be there until the 17th unless you post the bond, correct?
Okay, thank you.
Okay, thank you. Have a good day.
You too.
Do we only have one?
There's two more.
Okay.
Now before the court is Benjamin Mears of case 1934446 DM. Mr. Mears is here today after failing to appear before the domestic relations referee on December 15th, 2022. Bond is currently set at $1,389. This is the first bench warrant. He reports that he is self-employed. Last payment made on this account was in September of 2022. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on January 17th, 2024 at 8:00 a.m. before this court.
Mr. Mears, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on January 17, 2024 at 8:00 a.m. You will get notice of it in writing. Are you able to post a bond, sir?
Depending on what it is. That, I had some pretty bad luck get struck on my way. I got hurt. I had a trailer fall down on my foot and shatter my foot.
Okay, my question was, are you able to post a bond? Not all the details.
Yeah, depending on what it is, I guess.
I didn't catch that. You are or you are not?
Depending on what it is, what the bond is. I don't know what the bond would be. Yeah.
Well, the court does note that you have not paid in well over a year. So the court's concerned about that, but it is your first bench warrant. So what the court will do is I am going to modify your bond and set your bond in the amount of $500. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir. And thank you for the $500.
Thank you. Have a good day.
Well said.
You're free to go.
No for the court.
10% is better than the cut that YouTube takes. 30%. Oh, YouTube daddy. PayPal.
Is Thomas Wise of cases 092734 DP and case 111915 DS. In each of these matters, Mr. Wise is here today after failing to appear before referee Croteau on October 12th, 2023. In the 2009 case, bond is currently $1,292. This is the 9th bench warrant. In the second case, bond is currently $2,611, and this is the 8th bench warrant. He reports no employment. Last payment made on these accounts was in September of 2021. Front of the court recommends that reasonable bonds be set in these matters and they be scheduled for hearing on January 17th, 2024 at 8:45 a.m. before this court.
Mr. Wise, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on January 17, 2024 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
Not at the price that it's at now. No, I'm not.
Okay. Well, court does note that you have, in the one case, you have 9 bench warrants previously, the other one 8. You've not paid in well over 2 years. The court's taking all of that into consideration. I am going to reduce your bonds slightly. I'm going to put your bonds in each case in the amount of $1,000. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay, thank you. You're free to go. Have a good day.
And I have some bench warrants for the record, if I may.
Go ahead.
Andrew Eddy of case 212660 DP. Corbin Colon of case 093541 DP. Justin Caswell of case 051409 DS. Timothy Griffith of case 16678 DS. Joshua Hedden of case 181779 DM. Richard Levin of cases 061701 DP and case 06709 DS. Miss Stevie Whitmer of case 173731 DC. Haley Pountain of case 14609 DS. And Christopher Jones of case 163031 DP. These respondents failed to appear for their referee hearings. Front of the court requests that bench warrants issue in each of these matters pursuant to statute.
Court would enter bench warrants for Mr. Eddy, Mr. Cohen, Mr. Caswell, Mr. Griffith, Mr. Hedden, Mr. Levin, Mr. Jones, Miss Whitmer, and Miss Pountain in this matter as a result of their failure to appear at their respective referee hearings. The court would set their bonds in the amount of 25% of the outstanding arrears or $500, whichever is greater, and further would assess court costs of $150 in each case.
Thank you, Your Honor.
Thank you. You have a good day.
Thank you. You too.
All right, take care, Jeff. We'll see you later.
See you, Jesus.
All right.
Bye, Jesus. Also, thank you, Vicky. You're so sweet. You guys are so cute. Also, naked court could sort of be cool. I do look a little bit naked. I'm not, obviously. Like, but I get how it would look like that. Oh my gosh, me? In court? Right now? But thank you. I love this dress. It's one of my favorites. It's a strapless dress, and wearing it reminds me of Florida. where I wish I was.
Are you Bryson Crop?
Yes, Your Honor.
One moment, please. Ms. Crop, please unmute. We're ready for your hearing. Can you hear me? Hello?
Yes.
I'm asking her, ma'am, can you hear us?
Maybe one day, Courtney. Maybe one day, baby. We can see you now, the shirtless dad. Oh my goodness. I saw you earlier and I was so glad I even said that. I'm so glad. I don't know what was happening with your Google or your YouTube account, but Hector, he's got hair like you? What? Oh, Donna, you do too. I miss you guys. Arizona Fire, thank you so much. You guys are too sweet to me. You are too sweet.
Try that again, please. You can barely.
Yeah, Brittany, come on. Like, everybody's looking really nice today for court. If you could just, like, not yawn and be weird, that'd be great. Like, this could almost be qualified as an updo, Brittany. Okay, look, we'll pin it right there. Look, that's like an updo. Okay, so I'm gonna need you to fucking bring your red-hatted ass down to the game here and step it up. I don't know what's going on with you, but step it up.
We can barely hear you.
Ma'am, we can't hear you, so you're gonna need to do something to can communicate with us. We can hear you a little bit. It's broken up a little bit. It's a little bit.
Hold on, we need to have a talk about the dolls. We need to have a talk about the dolls above her. No wonder the signal isn't coming in. There's obviously possessed dolls up on the shelf behind her. That looks like what the fuck is in there? I'm bending over to look at my computer closer, but seriously, what in the fuck is in there? It looks like unfinished ceramics, and then the top level are surrounded by shot glasses. It appears to be very odd dolls. Some very odd dolls. At first, I thought, oh, this is a grandma's house because of all the ceramics or pottery in a like armoire or I don't even know what you would call that, a hutch. I guess we would call it a hutch. But or a cabinet maybe, but I don't know what. And then I saw the ones on the top. I don't know what those are. What are Hummels? If she lives with her grandma, somebody put the other dolls up at the top. They're drinking from the shot glasses, right? Like the pictures are grandma like. There's so much grandma like, but then there's something else. Something else. Also, this does remind me of when I worked at the very expensive furniture store and we would sell these dolls that were like $300 a piece that were fucking ugly. Absolutely fucking ugly. I'm about to pull up a picture of one of them on the phone and I'll show you what these stupid dolls look like. And I remember when the first order came in and I was like, "Oh my God, look at this." And I said to the guy who hired me, I was like, "Look at this. Some idiot is paying $300 for this doll." And he like looked at me. He was like, "Those are pretty big sellers." And I was like, "You're fucking joking me right now." I was like, this is like a reject from a children's toy maker. Like something that they would not fucking sell or give to a child. Something you have to remake. And he was like, "Yeah, they're really popular." I was like, I that and then the $1,000 bed sheets. Oh, that was a hard pill to swallow when somebody was spending like $4,000 on sheets for the bed. And they were ordering them like 4 or 5 months in advance and just paying up front and being like, yeah, just, get in touch. I'm like, yeah, we'll be in touch.
Jumping the screen, so. Ma'am, why don't you talk to us, see if we can continue to hear you and if it gets better. We can't hear you at all now. What? You're gonna need to speak to us for us to know whether your computer is working.
Can you hear me?
Yeah, it's all broken up. We won't. What we'll do is give you a phone number. You can call in on the phone number and we can do it that way.
Yes.
Okay.
Yes, because it's not working on video. Please call this on your cell phone, 64. Is that you, Ms. Crop, on the 26968?
Yeah.
Okay, hold on. Hello? Is that better now?
Yeah.
Okay. Let's call this case. This is 2023-1848 DM, Brittany Crop versus Bryson Crop. It is Wednesday, January 10th, 2024 at 8:48 a.m. Defendant is appearing from Calhoun County Jail.
This matter is before the court on the plaintiff's motion for entry of default judgment of divorce and for the final broken vessel hearing. Mr. Crop, are you disputing or contesting anything in this matter?
Oh, Your Honor.
Okay, thank you. Ms. Crop, what we're going to do is have you sworn in. We'll take some testimony and then we'll proceed.
Yeah, actually, before we're going to do that, we're going to look at the expensive dolls that I was just talking about. I found them. They're called Vitra dolls. Okay. And they've gone down in price since I first saw them, obviously a little bit, but they're still holding pretty steady here at, let me just hold that over there so you can see it. So, come on, zoom in. You can see, and each one of those is worth approximately like $200. And people literally buy all of them. Like you see the set is big. So we're talking like $4,000 or $5,000 for these dolls in front of you right there. If you wanted to buy the whole set, that would be like literally $4,000 or $5,000 because each of them is like $300 plus shipping. And again, please note the size. These are like mantle pieces. These are for like your mantle. They are not for like, look, they're on the mantle over here. You can see they're small. They're not fucking big. And I worked at this store and they sold really, really high-end furniture, right? These are called Vitra dolls. Vitra. Vitra dolls. And they are by is it George Alexander or something, like some guy? Gerard. Yeah, Alexander Gerard. But anyway, so those are very popular. But the other thing that we sold that shocked me always is actually, I'll pull it off here and I'll show you guys here in 1 second. So some of you have probably seen these in TV shows or in an expensive office somewhere, or you've heard about it, but it's an Ames lounger chair. So EAMES is the way that you spell it. It's pretty famous. They're sort of related to Herman Miller in a way, I think. Anyways, so the Ames lounge chair, like as soon as I show you it, you'll see. Yeah, it's Herman Miller. That's right. I did learn it proper. Okay, so and this is funny too because this was like the main training I got about this product. So you can see it's this lounge chair basically with the wooden on the side and then the leather in the front. And so the cost of this armchair or lounge chair is like $5,000 to $7,000 approximately, plus shipping. And it's in a lead time. Like you're gonna have to. It takes a while, right? So people want this chair a lot, but they don't want to pay for it. Especially cheap people. They're constantly like looking for this chair and at a discount. And when I first started at this job, they told me, they're like, you're going to need to always verify this one particular purchase very carefully. And I said, what is it? And so what it is that we also sold a miniature version of that chair. And that miniature version of the chair cost $1,500 and was, I'm not joking, doll sized, like for putting on your mantle, because to flex that you not only have a fucking chair in your office or whatever, but you also have enough money to spend like $1,500 on a doll chair to put on the mantelpiece that mimics the same chair. But what would happen is that people would think they're getting a really great a deal on an Ames lounger for $1,500. And so they would buy it. And then my job was to call them and explain to them that this is a 12-inch chair and verify that they did indeed want it, that it wasn't a full-size chair. Did they know that they were getting that? And most often, no, they did not. They were just all caught up in it thinking, oh my gosh, I've got the best deal on this Ames lounger. I finally found it. Like, oh my gosh. And so but I did one time sell one of them. When I phoned to verify, the woman was like, yes, we know. And I was like, you do? You know that? And she's like, yeah, it's a gift. I was like, a gift? That's a gift? You're giving that as a gift? And she said, yeah, well, I work at a law firm and one of the lawyers has been here with us for X number of years, and this is the gift. And I was like, you bought him a fucking replica of a fancy chair? A miniature replica of a fancy chair? Okay. That fucking job was crazy. Oh, and the sheets. I'm not joking about $1,000 sheets, guys. And I'm not talking about $1,000 sheet set. No, no, no. Each sheet was $1,000. So that's like the top sheet, $1,000. The fucking fitted sheet, $1,000. Pillowcases were like, I think $250 for a pillowcase. Easy. Easy. Waitlist for this stuff. People would pay in advance, months in advance, and then just waitlist for this stuff.
Okay.
Ma'am, do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Ma'am, do you have the final hearing, the divorce script that we would have provided you?
Yes.
You can go through all of that, but you don't have to disclose your address.
Okay. You want me to go ahead and do it?
Yep, go ahead.
Okay. The spouse and I were married on April 29th, 2021 in Quincy by a person duly authorized to perform marriages. I was a resident of the state of Michigan for at least 180 days and of Calhoun County for at least 10 days prior to filing the complaint for divorce now before the court. The allegations in the complaint were true when I filed it and are still true today. My spouse and I ceased living together as husband and wife on May 5th, 2023. There are minor children born of this marriage, and Brittany is not pregnant. There has been a breakdown of the marriage relationship to the extent that the bonds of matrimony have been destroyed, and there remains no reasonable likelihood that the marriage can be preserved. If the court were not to grant a judgment of divorce, I would not resume a marital relationship with my spouse. I wish to have my maiden former name of Great House restored to me. The reason for the breakdown of the marriage is there was just domestic involved. It's just time to go separate ways.
Okay. Court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court has the proposed judgment before me. The defendant has appeared, stating he does not contest or dispute anything. As a result, the court is entering that judgment and the uniform child support order in this matter. That will conclude the case. Best of luck to both of you. I hope everything works out for you, and you're free to go. Have a good day.
Thank you. Have a good one.
All right, thank you, sir. All right, so now let's go on to the next one.
We don't have one. Judgment on persons.
Yeah, I'm gonna send that to you. They have an opt-out order too. Please unmute both of you. Mr. Parsons, we're ready for your case. Hello?
Hello.
I'm waiting for Mr. Parsons here and see. He needs to be unmuted before I call the case. Can you, Mr. Parsons, Kenneth Parsons, are you still, are you there?
Hello?
Yes, okay, thank you, sir.
Jonathan Miller, if she bought you a miniature Ames lounger, would you feel bad never being able to even sit in it? Also, honestly, I think that having a nice chair is great. I'm going to be honest. When I worked for that company, I got to sit in really nice office chairs, like really, really good Herman Miller, top of the line office chairs. And they make a difference, a huge difference when you're working. Like, it's nuts. Okay. The ergonomics of real ergonomic like stuff like that is well worth it. If you sit in a chair all day and you have enough money to buy a decent office chair, that's where I would spend the money. And they're not that $10 million. I swear to God, Courtney, you can get a decent one for probably like $600-700. You could do a decent ergonomic like Herman Miller, and I bet in the States it's even cheaper. But well worth it, and they're tested and rated to, like 24-hour use, like for call centers and stuff, so that people are using them 24/7. So they don't wear out fast, and but the difference is incredible when you find one that you actually like. The Aeron, yeah, but the Aeron's basic. There was a chair like 2 or 3 above an Aeron. I'll have to remember the name. Oh, Mitra. I think it was Mitra. Anyways, or the Mira or something anyways, whatever the chair was, I remember I got to use it, and oh, it was beautiful. I loved it. It was so amazing. Yeah.
Thank you for your patience. So this is 2023-1778 DM, Emily Parsons versus Kenneth Parsons Jr. It is Wednesday, January 10th, 2024 at 8:52 a.m.
Good morning to both of you. In this matter, Mr. Parsons, I'm looking at the paperwork, and I see that it does contain your signature.
Okay, I need to be I need to be honest because the chair that I was just talking about is a $2,000 chair. I apologize. Oh, damn, but it was so good. Is the Aeron really $2,400? Wow. They've got it on sale for $1,600 and it's called the Mira 2, Mirra. I did love that chair though. Like fuck, it was so good. So Oh, for fuck's sake. No, hold on. Paisley, can you just fucking not do that? Ay, Faye! Oh my god, I'm knocking shit over left, right, and center. Anyways, it looks pretty average, but god damn it, I swear to god. Oh, green screen? So good. So good. Again, businesses doesn't massage. No, there's no massage, but you don't need you don't get a sore back or a sore body when you sit in a chair like that, even if you sit for 8 or 10 hours a day. Like that's the difference is that you're not sore and stiff and fucked up. Like it is cushioning and like supportive in really good ways and built ergonomically so that it's supporting you in really, really, really helpful ways in terms of the arm rest and all that kind of stuff for typing. Couple that kind of chair with a sit to stand desk, and that is pretty much the ideal working scenario for me. That would be like perfection.
Is that correct?
Yes.
Okay, so you're not disputing, you're not contesting anything.
No.
Okay, thank you. Ms. Parsons, we're going to take some testimony from you. So we need to have you raise your right hand and be sworn in.
Ma'am, do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes. Courtney, I put a cheap standing desk on my Amazon wish list. If you look at it, because I think it would be perfect for me filming, because I miss standing up filming and I want to be able to stand up, but I'm trying to keep the computer in one spot. But if you look on my Amazon wish list, I have a standing like rolling desk that I think is like $80. Again, I put things there so that I remember to buy them later if I ever get money.
Ma'am, you can go ahead and you can go through the script that we would have provided you. You do not have to, again, you do not have to state your address if you don't wish to.
Okay, I don't mind. My full name is Emily Renee Parsons. My address is 160.
We mind.
All the statements in my complaint for divorce are still true today. There has been a breakdown of the marriage relationship such that the object of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved. I do not believe there is any possibility of reconciliation. I am not currently pregnant. The defendant and I have one minor child together. The child's name and age is Kenneth Robert Parsons III, and he's 3. I have read all the terms of the proposed judgment of divorce, and I agree with them. I ask that this court grant an absolute judgment of divorce. Thank you, Your Honor.
Thank you. Court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The file does appear to be in order. We have a signed or a consent judgment in UCSO submitted bearing both of the parties' signatures. The court will therefore enter that judgment, which I have done. You are now divorced. Best of luck to both of you.
The big D. Can we get some big D's in the chat for the divorce? Ladies and gentlemen, look at that. The big D divorced. Let's let him finish talking about this and then we are pretty close to calling it quits. I think Colin has a live going on later. I have a couple things to do tonight, another video to put out. Yes. But seriously, the big D, because he's divorced them. Part of me loves these little divorces. I did hear one case where they said that she was pregnant and they would not allow the divorce because she was pregnant. They then require them to stay married until the divorce is complete, and then or until the pregnancy is complete, and then they will grant a divorce. That's why they asked that question. Okay, let's let this finish off for a little bit, and then we are going to be done.
I hope everything works out for you, and you're free to go. Have a good day.
Thank you, Your Honor. Have a good day.
All right, thank you. So.
Okay, stay for one more.
Please unmute both of you.
We have.
Yeah, the 181st day is tomorrow for that one.
Okay.
The lottery. I did tell or inform the plaintiff. I checked her in. Please unmute both of you. We're ready for your hearing. Hello. Please unmute, ma'am. You're still muted.
Also, yeah, if only divorce was this simple, people that need to do it would be able to do it super duper easily. But unfortunately, that's not the case everywhere. Also, what is her name? There are 3 A's in it. That's a guy. That's a woman. And how do we pronounce her name?
Ma'am, click. Okay, you got it.
Okay, can you both?
Okay, and they both have different spellings of their last name or different organizations of the spelling. Same letters, just different order? What? You can't even agree on how to spell your fucking last name? That's how dissolved your marriage is?
Hear us now?
Yes.
Yes, I can.
Okay, thank you for your patience. Excuse me. This is 2023-1877 DM, Arian Delattre versus Jonathan Delattre. It is Wednesday, January 10th, 2024 at 8:57 a.m.
Good morning to both of you. I'll go
Good
to
morning,
you.
Your Honor.
Go to you first, sir. In this matter, is before the court on the plaintiff's motion for entry of a default judgment. And in this matter, have you or do you dispute or contest anything that is in the proposed judgment?
No, I do not.
Okay, thank you. Mr. Delantre, what we'll do is we're going to have to take some testimony from you. So if you would raise your right hand, we'll have you sworn in, and we'll proceed.
Ma'am, do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Ma'am, you can go through the script that we provided to you, but you don't have to state your address if you don't wish.
My name is Arian Janae Delattre, and I am the plaintiff in this case. I married the defendant on October 31st, 2014 at Battle Creek, Michigan. I filed a complaint of divorce on July 14th, 2023. I lived in Michigan for 180 days and in Calhoun County for 10 days immediately prior to filing this complaint. When I filed this complaint for divorce, all the statements were true. all the statements in my complaint for divorce are still true today. There has been a breakdown of marriage relationships such that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved. I do not believe there is any possibility of reconsideration. I am not currently pregnant. The defendant and I have 2 minor children. Their names are River Janae Delatre, she is now 12, Draven Lawrence Delatre, 9. I have read all the terms of the proposal judgment of divorce and I agree to them. I would like to keep my last name. That's the only thing that has changed because the kids requested that I keep their last name, if that's okay. I ask the court that this court grant an absolute judgment of divorce. Thank you, Your Honor.
Thank you, ma'am. The court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. This matter, the court does find the file to be in order. The defendant has appeared, stated he does not dispute, does not contest anything contained in the judgment. As a result, the court will enter those, but I have to wait until tomorrow because today is the 180th day. Has to be a 180-day waiting period, but they will get entered tomorrow. And at that time, your divorce will be concluded. And best of luck to both of you. I hope everything works out for you. And the court will end this proceeding at 9:00 a.m. You're free to go. Have a good day.
All right.
Thank
Thank
you.
you, Your Honor.
Okay, well, we're divorced as of tomorrow, so let's go fuck tonight. I guess. Is that what you should do on your last night of not being divorced? You have sex, or is that just me? Just my brain, probably. Probably. Tend to be inappropriate. Wow, that took a long time for that to come up, didn't it? You guys, I hope you've had a wonderful evening. It's been almost 2 hours. We watched a lot of different court, but I really enjoyed it. I want to remind you, yeah, breakup sex is important for closure. That's actually very true. I'm a Hundy P on board with that. But, you know, I don't have sex with, I don't know. I did never had sex with my ex after we separated. Not even one time. Not even one time with my ex-husband. Anyways, I hope that you guys hope Oh, I could hear somebody rustling around somewhere. Okay, I hope you guys have a wonderful evening. Thank you so much for being here. Make sure that you hit the like button. It is super duper helpful and free for you to do on the channel. I appreciate each and every one of you, and remember that I love you. I'm proud of you. And I will see you in the next one. Bye, Christy. Bye, guys. Bye. I said bye.